Can a preliminary hearing get your criminal charges dismissed? Imagine standing in a courtroom, hearing your case being discussed, and wondering if it could all end right there. That moment is what a preliminary hearing is all about. It's an early step in the criminal justice process, especially for felony charges. The main goal is for a judge to decide if there's enough evidence to move your case forward. It's not about guilt or innocence, but about whether there's probable cause to believe you committed the crime. Probable cause means there's a reasonable basis supported by facts that you might be responsible. This standard is lower than what's needed for a conviction at trial, which is beyond a reasonable doubt. During the hearing, the prosecution presents evidence and calls witnesses to support their case. You, as the defendant, have the right to cross-examine those witnesses and challenge the evidence. If the judge finds that the prosecution has not met the probable cause standard, your charges can be dismissed. This means your case won't go to trial. Several reasons can lead to dismissal at this stage. If the prosecution lacks enough evidence to support probable cause, the judge can decide to dismiss. If witnesses give inconsistent statements or have questionable backgrounds, their credibility can be challenged. If the judge finds witnesses unreliable, that can also lead to dismissal. Evidence obtained illegally, like through an unlawful search or seizure, can be excluded. Without that evidence, the prosecution's case weakens, and the judge might dismiss the charges. Defense attorneys can also file pretrial motions to challenge the legality of evidence or argue that the charges are not valid. If the judge agrees, the case can be dismissed. It's important to remember that even if charges are dismissed at this point, prosecutors might refile them later if they gather new evidence. But for the defendant, a dismissal at the preliminary hearing can be a big win. It stops the case early and can save you from the stress and expense of a trial. From a defense perspective, the preliminary hearing is a key opportunity to challenge the prosecution's case. Skilled defense attorneys use this time to expose weaknesses, question witness credibility, and push for dismissal. It's an important step to protect your rights and possibly end the case before it reaches trial.